Hi there, this is Erica Merrill, and I am the founder of Perfect Legal Video. I am very excited to bring to you today, again, 2 weeks in a row here, attorney Jim Sorenson out of the Sorenson Van Leuven law firm. They are based out of Tallahassee, but they work with credit unions in Georgia and in Florida. Thank you so much for joining us today, Jim.
Thank you for having me again, Erica.
We love having you. And what I love about today is that we are actually going to work off of a topic we talked about last week. And I'll let you give a little bit of a review of that. But just for the folks today, we are going to be talking about even more repossession pitfalls. Last year, we were talking about sending out the wrong letters and getting in a lot of trouble financially over getting sued, even getting a class action lawsuit against a credit union, which could even put the credit union under and out of business. So, Jim, I'm going to let you give a little review of what we talked about last week, and then we can move forward with this week's topic, which is the extension to last week's topic.
Well, thank you, Erica. Last time we talked about repossession letters. We talked about a risk alert that had gone out from CUNA Mutual, and we at our firm have been getting a lot of questions and concerns about that risk alert. And so we talked about the ins and outs related to repossession letters and how those are risks that you need to control. And so this week, I really want to talk about other risks, other pitfalls related to repossessions in addition to the repossession letters.
So that's great. So, what are the other risks that a credit union might find themselves against when they are considering repossessing property from their members?
So the big risks I see are of what we would call a wrongful repossession. Um, Also, the other risk is avoiding a breach of the peace or how they handle personal property left in the vehicle. Those are really the three big items that I think credit unions need to be aware of and need to have procedures, processes in place to protect themselves.
Wow, you know what? I never even thought of that. When they are repossessing these properties, whatever it is, whether it's a car or whether it's um, an RV or a boat, I mean, there might be precious property left in those that don't belong to the car or have anything to do with it. Maybe somebody left their wedding ring in there. I mean, what do you do in this case?
Well, when it comes to personal property, and we are talking about the items left in a car. So over the years, I've seen all sorts of things, everything from, like you mentioned, jewelry to wallets to firearms, sometimes illegal items left in a car, which are handled different. We won't talk about that today, but I've gotten a call about drugs in the car. But assuming it's normal personal property, nothing illegal, each state has a process or procedure on how that is supposed to be handled. And for example, in Florida, the recovery agent, the repossession agent, is supposed to go and create an inventory of what's in the car. So they go through the car, they make a list of everything that's in the car, and then they're required to send notice to the owner of the vehicle that these items were found in the car, list them out. And it may be one item or could be 10 items. And explain how they go about claiming the property. The issue that comes up is they will charge a fee, and the CFPB has said, which is the Consumer Financial Protection Bureau, has said that you cannot keep a consumer from claiming their property by charging them a fee. So if the recovery agent's going to charge a fee for the notice and for the inventory, that is a fee that has to be passed on to the creditor. The creditor can add that to the loan if their loan provides for the reimbursement of those costs, but you can't hold their property hostage in order to charge them that fee. And so that is one of those issues that credit unions need to be aware of. And what I find a lot of times is credit unions aren't aware of that, and people's property is being held subject to the fee, which is illegal.
Wow, that's a really good point you make. I got to thinking about something else. Since we were talking last week about the letters going out and how sometimes the letters would go to the wrong person because, so many people have the same name. There are a lot of common names out there, or there's a situation where, there's a junior. And so there's a lot of mix up when it comes to that. I mean, is it possible that, the properties are ever taken from the wrong person?
That happens. I've seen that happen, or know of that happening on several occasions. I've gotten a call, Jim, what do? We repossessed the wrong person's car. And again, it's usually in the situation where it's a common name. So John Smith, right? Or Bob Smith, or some other common name where maybe the credit union has 5 borrowers with the same name. And through an error, it's simply human error, the wrong car is identified for repossession. So the recovery agent goes and repossesses the car of someone who's paying, someone who's current on the loan. And so that's what, when I first mentioned wrongful repossession, that would be what we would call a wrongful repossession. You repossessed a car you weren't entitled to.
What a nightmare. I can't even imagine you come out from going to the bank or getting groceries and your car is missing and you did nothing wrong.
Yeah, I mean, that as you can imagine, the credit union or the bank or whoever it is took my car and I've made every payment on time. You could imagine how angry that person would be. And
Oh,
their first calls to the police, right? Someone stole my car. And usually the police are informed that a repossession happened. So they say, oh no, your car was repossessed. And now the second call is to a lawyer. And the lawyer is like, oh, we got a good one here. We're going to make
oh.
some money.
Oh my gosh. And then it's your client, which is not a laughing matter, that ends up having to have that headache and lose that money over either defending it or whatever other fees occur from taking the wrong car. And I'm sure that there's plenty of punishments and things that happen with that. How can they avoid a situation like this?
Yeah, so the it's very important that they have good procedures, and those procedures should require an approval process, so that the person who makes the recommendation for repossession and who fills out all the paperwork, someone is looking over it, giving final approval. We have the right John Smith matched with the right car. Yes, this John Smith and this car are the right one. Yes, this situation is such that we're entitled to go get the car. We're entitled to go repossess the car. So it's important that they have a process or procedure, and that process or procedure is followed. And there are checks and balances that try to eliminate human error, because really what we're talking about here is human error, and you need a process to avoid or limit that human error.
Human error. That is really what gets us all, isn't it?
It does. Human error. I used to have a partner who would he's actually my boss, and then a partner who would point to a pencil and ask you what was on the end of the pencil. And you're supposed to say an eraser, and he'd say, well, you know why that's there? Because us humans make mistakes, and human error is a real deal and can cost a lot of money. And so you've got to try to control or eliminate that human error.
I agree. So there was another interesting thing that I heard you mention earlier, and that was a breach of the peace. And I can absolutely imagine that a lot of drama could possibly go down when you are towing away somebody's boat or car, or maybe even their mobile home. W- Tell us a little more about this. It's a stunning realization to me to realize that all of these credit unions have to handle these situations so gingerly just to get their money back on a bad loan.
Yeah. So breach of peace is a concern, and that term is kind of a term of art. It's a legal term, and what it involves is when the recovery agent goes to recover the car or the RV or the boat, whatever it is, and during that process of recovering the car, there is an altercation with the borrower, maybe with a family member of the borrower. It doesn't always have to be the borrower, it could be a family member. Or there's damage to the property, or they just engage in illegal behavior. All of that would fall under what we call breach of the peace. And so the idea is that in most states, Florida and Georgia for sure, but most states have what we call self-help repossession. So that means you don't have to get a court order to recover the car, but self-help repossession is only allowed as long as you don't breach the peace. You can't use violence to recover the car. You can't use force, and you can't damage other property, and you can't get in a fight. So, this is, example, the car's sitting in the driveway, and the repossession agent comes, sees it in the driveway, goes to back up to it with the wrecker truck to repossess it, to tow it away, and the owner of the car or a family member runs out and stands between him and the car, stands between the wrecker and the car, right? So now the only way the repossession agent can get the car is to get in a altercation with the family member. Well, that would be a breach of the peace. At that point, the repossession agent just has to leave. And so, this is any time that agent does something that, again, breaches the peace. And that's the concern. That leads to a claim against the credit union.
Wow, there are just so many moving parts to repossession. And I'm glad that you're alerting us to all of these gotchas that could happen and cost a credit union a lot of money. So, could you tell us what is a good way to limit the breach of peace situation that could occur when you are repossessing properties?
Well, first and foremost, I think credit unions have to do a good job vetting, investigating the repossession agent they hire. You don't just because someone has a wrecker truck and says they're a repossession agent doesn't mean they're going to handle it in a professional manner. And I think what sometimes people forget is you're hiring this agent, but they're acting on your behalf. And as your agent, anything they do can come back and affect the credit union. So if they handle this in a illegal manner, not only can that result in bad press for the credit union, but it can result in a lawsuit. And so you want to thoroughly research and manage your recovery agents. You want to make sure they're licensed, they're insured. You want to make sure they have references, and you've checked those references. Yes, they've handled repossessions for other companies, other banks, other creditors, and they've done a good job. They've not been reckless. Second, and this is just as important, is you need a good contract. A lot of times it surprises me how often credit unions will engage a repossession agent and not have a good contract. The contract should protect the credit union. So it requires the recovery agent to maintain insurance. It requires the recovery agent to do certain things, such as not breach the peace. And then it provides a way to recover any damages the credit union suffers from that recovery agent. And then finally, the credit union has to investigate any claims they receive regarding a recovery agent, no matter what it is. So, if a consumer complains about the recovery agent, maybe not, they don't file suit, they don't go see a lawyer, but they say, this recovery agent did X, Y, and Z, the credit union needs to investigate that, because if the credit union is aware of a problem and turns a blind eye to it and continues to use that agent, then they're just creating a worse situation. It becomes they knew that this was a potential and they did nothing to prevent it. And so there has to be this active management of the process, the contract, and then the follow-up to make sure that any claims that are raised, any complaints that are raised, are properly investigated. And a lot of complaints are not going to be true, but you still have to investigate and make sure you know what happened and what didn't.
Wow, that is so true. I mean, it's great that you have the process is to give your clients so that they know what to look out for, because you can't know everything. And that's why they have you. Because you've seen this over and over again with the plethora of credit unions that you work with and all of the situations that you see on a daily basis. So it's really great. So now there was another thing I wanted to ask you about. You were talking about, personal property found in a vehicle, for example. Now, does this pertain to a brand new sound system that they just put in the vehicle, or is it personal property, like, clothes? I mentioned jewelry earlier because I would worry about taking something off and leaving it in there. Maybe it was their favorite, CDs. I don't know. What are you referring to exactly when you talk about the personal property left behind?
Yeah. So when we were discussing the personal property left behind, I'm not talking about items that are attached or become part of the vehicle. So, if the consumer bought a new stereo system and put in new speakers and a new radio, under the law in Florida and Georgia, those are viewed as part of the collateral. Those are viewed as part of the car, or part of the boat, or part of the RV, depending on what we're talking about. So it's not those things. It's not the items that are affixed or become part of the collateral itself, meaning the car, the boat, or the RV, but it's those personal items left behind that aren't part of the vehicle. So like we talked about, the rings, the clothes, the, personal items that can be left behind in a car. Just think about your own car and what may be in your car right now. Different people have different things they leave in their car. And so any of those items that would be in your car that aren't part of the car, aren't affixed to the car, are the items you're entitled to get back.
What are the claims that arise when it comes to this personal property?
Well, the claims would be that you're improperly holding their property, that you are under Florida or Georgia law, it would be that you converted their property. Conversion would be the claim, and so they would be able to sue you for the value of the property, and any other damages they suffered. And as you can imagine, they're going to always say the value of the property is more than probably what it's worth, but that's what you get to fight about in court, which is something you don't want to do.
Hey, sometimes you spend the amount of money or more than what the value of that property is.
Yes. Oh yeah. Yeah. To defend these types of cases are not cheap. And in most situations, when lenders are faced with these claims, usually you're going to want to settle, because the cost of litigating these are expensive, and the danger of not just having to pay damages to the consumer, but if the consumer prevails, in a lot of these cases, the consumer is going to get attorney's fees on top of that. So the lender runs the risk of not only paying its own lawyer, but having to pay the lawyer that sued you. And so that pressure leads to settlements in a lot of these cases. And of course, it can lead to bad press.
So, how can you avoid these types of risks? And how can you help your clients avoid these types of risks? Because it seems like there are just so many traps that they could step in.
So I think number one, and we've talked about this before. We talked about it in the last interview when we were discussing the repossession letters. But you have to have good repossession procedures, and those repossession procedures need to be up to date with the law and up to date with the risks that we're seeing. Um, and that is something we can help our clients do. We often will review their repossession procedures, provide them additional insight into where maybe there's a weakness, maybe something's missing, and help them get their procedures such that they're in a that they're thorough enough to avoid a lot of these claims. Beyond that, once you have the written procedures, you need to make sure your staff are doing what they're supposed to be doing. It's one thing to have the procedures, that's great, but if your staff is ignoring the procedures, then you don't have the protection. So there needs to be an audit. There needs to be a review to make sure that in certain repossessions, all the boxes were checked, all the I's were dotted, all the T's were crossed. And that is something that we do. We will come in and work with our clients and review repossessions. And, they might ask us to look at 10 repossessions that happened over the last 6 months. We pick them randomly and we go through them with a fine tooth comb, so to speak. And we look for any potential issues, anywhere their mistakes were made. And, if there was a breakdown in process, and then that may lead to, okay, the process, the procedure needs to be updated, or it's a training issue and we just need to coach and train the employees. And of course that leads to the last thing, which is the staff training, which is what we do. So we train on these issues all the time for our clients, help provide this training. So that's how we work with the clients, helping them with their procedures, helping them audit and review to make sure the procedures are being followed, and then the follow-up training that needs to be done.
I think that's really interesting that you say that, because honestly, you feel like you train somebody once and you've got it. You might have a giant training for your whole staff, but guess what? Some of those people leave and you get new people in, and maybe your clients try to train them themselves, and then that person really doesn't get why that procedure is so important. So they may not think it's a big deal to skip a step here or there, and then they end up causing the credit union the whole business, which is possible. All they got to do, just like you said last week, is send out the wrong letter for the last 3 years, and then they've got a class action lawsuit. So with that being said, like, you can comment on this. I just wanted to see, were there any other comments you wanted to make about this topic today? Because I know it's been thoroughly gone over, but there's always more.
Yeah, there is always more, and we kind of hit on the three big ones. I think if I would add anything, I would add that they need to be careful when dealing with deceased borrowers and their family. This is something that I see happen, and in Florida especially, because we have a large senior citizen population. A lot of people move to Florida to retire, and so a lot of my clients in Florida have large numbers of senior citizens. It's not uncommon that when they die, they have an outstanding auto loan or a boat loan or an RV loan, because again, they were in their golden years traveling in their RV, whatever the case may be. And the credit union will often get calls or contacts from family members about the loan, about the collateral. And it's human nature. We feel sorry that this son or this daughter or this sister or this brother is dealing with a death, and we want to help them. And what ends up happening is, out of compassion and out of an effort to help, the credit union crosses a line, and they share confidential information with a third party who has no right to that information. And there's a process and procedure to go through, and that process and procedure is going to vary from state to state. How you may handle that in Florida is going to be different in Georgia and different in another state. And so, when the credit union is dealing with third parties and a deceased borrower, they need to make sure that they understand what the law is, who has a right to that information and who doesn't. And in most cases, they need to seek legal advice. And so don't let your compassion and your desire to help someone lead you to committing a bad act or a wrongful act, if you will, that opens you and the credit union up to liability.
That makes a lot of sense, and it's great advice. I want to thank you so much for joining us again today and sharing this very important information for credit unions. I will mention that if there are any questions out there from the audience, definitely pick up the phone and get Sorenson Van Leuven Law Firm a call, because if you've followed any of their social media, I personally handle a lot of that, and I get to see firsthand all of the testimonials that come up talking about how SVL Law Firm really treats their clients like family. They're very thorough, and the training is key. Really, it comes down to your bottom line. And when you have someone helping you recover things that you need to recover for your business so that you have the revenue, I mean, it's a very serious situation for a business, any type of business, not to have somebody that is watching out for them in this regard. So any question at all, pick up the phone, call Jim. He's got a large and very capable staff, and they are looking forward to helping you out.
Thank you, Erica.
You're welcome. Have a great day, and I look forward to talking to you very soon.
Me too. Thank you.